Right. Hello, everybody, and welcome to day 3 of the Legal Tech webinars. Though it is the last day, it's definitely not the least. So on that, I will be handing over to Professor Stephen Hardy, who is moderating this panel, The Impact of AI on International Arbitration. Thank you.
Good morning, everybody, and can I join Jasmine in giving you a warm welcome to this wonderful webinar on a very interesting and, of course, an emerging topic, the topic of AI and international arbitration. Just a few words before we begin, that if we can all mute unless we are speaking. More to the point, we are here to have a discussion. So the plan is that I will introduce the panel will introduce themselves, then we will move straight into our panel discussion, after which there will be a Q&A. I think the key thing is in the discussion that throughout, please feel free to raise your hands and more importantly to keep the chat going. And I, as the moderator, will ensure that that is fed into our discussion and our Q&A in due course. So there's a few rules. For those of you who had technical issues, I've had some this morning. If you drop out, feel free to rejoin at any point. I, as the moderator, if the panelists fade away, I'm sure that we can keep the discussion and the conversation going, because the word conversation is truly what these Forte legal webinars are all about. So, without further ado, we've got a lot of themes to get through. Some, as you might expect, typical themes in terms of ethics, legalities, risks, regulatory, and of course, realism of artificial intelligence in international arbitration. So, dealing with those themes are our very experienced expert panel, who are now going to introduce themselves. So firstly, I'd like Lise to say hello and introduce herself.
And with the classic, I will start talking without having unmuted myself. Hi, I'm Lisa Alm, and I am Head of Business Development at the Stockholm Chamber of Commerce. And I'm a lawyer by training, but I actually have a background more in startups and tech. So for the last 10 years or so, I was in startups, especially quite a long time with Spotify, and then with some other startups as well. So at the Stockholm Chamber of Commerce Arbitration Institute, I work with business development, and tech innovation, tech implementation, and trying to be as visionary as we can. So that's briefly about me.
Thank you, Lisa, and welcome. And next up is Minesh.
Thanks, Stephen, and hello, everyone. It's a pleasure to introduce myself for this session. My name is Minesh Tanna. I'm a dispute resolution lawyer at the law firm Simmons & Simmons, and I focus on technology-related disputes. Half of my cases tend to be international arbitrations, again, principally in the technology sector. I'm also head of the Artificial Intelligence Group at Simmons & Simmons. We're a group of international lawyers advising clients on legal, regulatory, and ethical issues. And we're also involved in policy development in AI through membership of bodies such as the UK CBI's working group on AI. Now, as a dispute resolution lawyer, I tend to think rather pessimistically about worst case scenarios. And when it comes to AI, whilst I agree with what the CEO of Alphabet, Google's parent company, said about AI being as profound for humanity as electricity, I often find myself speaking more about the risks associated with AI, which I'll cover later on today. Stephen.
Thank you very much, Minesh. And I've just been reminded by one of our participants, are we going to have chat throughout? Yes. Are we going to have Q&A? Yes. When Q&A arises, it will be Q&A time proper, but in the meantime, we're having chat. So a warm welcome to Minesh. Next up is Paresh.
Hi, Stephen. Thank you very much, and thank you to Forte for the opportunity this morning. So my name is Dr. Paresh Kafrani, and I am the Director of Education and Training at the Chartered Institute of Arbitrators, where I oversee our physical and virtual training courses in ADR disciplines such as international arbitration and mediation. Before I joined CIARB, I was a senior lecturer in law at the University of Westminster, where my research was in legal technology and ethics. Here I wrote on ethics, chaired several panels on AI and law, contributed to a parliamentary report, and also worked on an EU-funded project on developing natural language processing tools in the fields of family law and other areas of law. I have worked on other technology-related projects, including using virtual reality in legal education. And my research interests are bit different. They're in the fields of philosophy, epistemology, and artificial intelligence, and especially on the way in which technology will influence the legal education sector going forward. And it's a pleasure to be here today. Thank you very much.
Okay, thank you, Paresh. And next is Tom Snyder.
Hi, good afternoon, everybody. It's a real pleasure to take part in this webinar. Again, my name is Tom Snyder. I'm a partner and head of arbitration at Al Tamimi & Company based in Dubai. Been based here in the region for about 3 years. Prior to that, was based back in the United States. You know, like most arbitration practitioners, sort of feeling our way through the recent developments brought on by COVID-19 in terms of remote hearings and technology, have a growing interest in these topics and artificial intelligence in arbitration. I think throughout the webinar today, I'll be approaching these issues from more of the practical aspect, how this is likely to play out in practice. Thank you.
And welcome to you, Tom. And Tom's just explained for everyone who's participating that today will be about practice as much as it will be about the theory. And now we move exactly in that theme to Anil. Good morning, Anil.
Yes, good afternoon. Anil here in Singapore. We are 5:40 in the evening. All right, I'm a dispute resolution practitioner as well. 60% of my work is construction disputes. The rest I do everything from crime to divorce to medical negligence, personal injury in the works. I sit as an arbitrator, mediator, as an adjudicator as well. And I dabble a little bit in online stuff that I've published in the Asian Journal of Mediation on online dispute resolution and where it's headed to, what kind of technology there is and what kind of issues that can arise. So practical sides, I'm going to be speaking about the practical aspects as well on what could possibly work with AI in arbitration. Thank you.
Thank you, Anil, and welcome. And last but not least, Lise Thomas.
Hello, everyone. Thanks for joining. I'm Thomas Vale. I'm the founder of Vale Dispute Resolution, a boutique practice in London focusing on international commercial arbitration and investment treaty arbitration. I act as counsel and I also sit as arbitrator. Today, I will have the opportunity to close out the session and envisage a little bit how the future might look for using AI in international arbitration.
Okay, and warm welcome to you, Thomas, and thank you all panelists for joining us. I think we'll all agree, those of us who are participating, that this is an extremely experienced expert panel, so it's going to be a very interesting discussion that we have. So let's begin that discussion. So let's start with Lise in terms of, for us in arbitration or any dispute resolution, how far are we from being replaced by artificial intelligence?
Well, that kind of is the million-dollar question, I suppose, or rather probably billion-dollar question. So I would say that the short answer is quite far in terms of actually being replaced. The somewhat more nuanced answer, I'd start with saying that we are already heavily enhanced by technology, AI and other types of technology, and we need to continue to be that because the situation that we have today, where we're struggling with, I saw an OECD report that we have about 50% of the world's population that have a lack of access to justice. We have quite a lot of issues with backlogs and other issues in courts. We do need to try and adopt as much technology as we can to tackle the issues that we have today. But to start answering if we can have AI judges, we kind of need to start defining what is an AI judge. What do we mean by that? And I would say that if the answer is, I want this omnipotent super machine that can answer any question like a human would, then we're quite far away from that. Today, AI is made to order, it's made for specific applications, it's great for repetitive, maybe less complex issues. In terms of being completely replaced, no, there's quite far away from it. But in terms of being enhanced, we're already there. And I also want to point out there that that's not just in AI, that's in tech in general. And if we were to fully adopt all the technology that we have today, never mind AI, we would be a lot further along. But still, to answer the question on AI judges, I wanted to break it down into, first, is it possible? What is needed? Who will do it? And what will that mean? So in the first question, is it possible? Well, to repeat a little bit what I said, then it's this is better for the repetitive and non-complex issues. So that means that when it comes to permit appeals, or when it comes to smaller cases, this is already in the works. This is already being used by court systems throughout the world. Well, not throughout, but in more tech-lean forward court systems already today. When it comes to the more complex things, it's more about maybe enhancing the human than it is about replacing the human. And this development will keep going up the chain of complexity, and it will be, especially will keep going up the chain of adoption. And how far and how fast, I mean, that ties back to that $1 million question at the beginning. The next one then is what is needed to do it. And you need to have a mix of technical competence, legal competence, data, tons of it, money, quite a lot of it, and an incentive and vision to want to do that. And if you start looking at who will the actors be that actually can have these components, that can tie them into one, if you look at the actors of our world today, you have the judiciary players, such as, for instance, individual arbitrators. And if you look at the list of what you need to do that, your individual arbitrators are likely not going to be the people that bring this out because it's a very daunting job. So you need to collaborate with others to be able to do it. And individual arbitrators don't necessarily have that combination of assets. If you then look at the state judicial systems, well, there are, and see, are they going to be the ones bringing this out? Then there are a lot of states that have shown evidence of both really visionary, inspiring, and sometimes quite scary examples of what you can do when you really push the limits. You have some examples out of China where that is really exciting and somewhat scary. You have examples from other ends of the world as well that also are using AI. But then you also have, if I were to look in my home jurisdiction of Sweden, and I look at how far the judicial system has come here, there's no AI judge in sight. We're looking at digitalization that is much more rudimentary than that. And I know that UK has a huge digitalization project going on in the judicial systems, but not a lot of that money is geared towards AI. So they're not likely going to be landing an AI judge based on that, that funding yet. If I look at the institutions, the arbitral institutions, I represent the innovation arm of one of what I want to say, one of the more innovative ones, and I can still say we don't have it up our sleeve. If you look at what we have legal competence, we have heaps of data, we have the incentive and hopefully the vision, but we don't have the tech competence and we don't have the money to buy that tech competence. So then you start looking at, okay, but who's left? Well, we got the parties, often backed by law firms. So law firms can be really savvy, but when it comes to actually themselves in-house generating AI to a degree that they could actually be an AI judge, I'd say we still have some ways to go. So then the really interesting parties that remain here is actually, there's two that I've left out. And one is third-party funders. And if you look at that list of assets that you need, third-party funders actually tick the box of a lot of them. They do have legal competence, data, money, incentive, and with money you can buy tech competence, so if they don't have it in-house already. Whether that means that that is actually happening, I think that's a question to ask them. When I've got quite evasive answers, so we'll see. And the other one that is actually coming up with this is tech companies. And then you need to ask the classic question of following the money, who buys these products? So the ones that, again, you have the parties that have the money to buy these products are the party representatives and the law firms and the third-party funders, rather than maybe judicial systems and institutions. But that also means that the gear towards what is actually coming out is going to be coming out towards party assistance rather than judicial assistance. And I think that's quite interesting. So I think we're going to be, to cap this off, I would say that we're going to be seeing AI lawyers soon, that we're going to be seeing AI judges. And that brings really interesting questions on how a human judge will handle a robot lawyer, and the
Okay.
balance of forces there.
Okay, so some interesting questions there. I mean, there's two questions that immediately come up from some of our participants. So Lise, quick fire response to, does AI enhance access to justice rather than hinder it? And the second question, if AI judges are far off, when they arrive, will they be better than the human judges?
Both really good questions. So the first one, I would say that it's a double-edged sword when it comes to access to justice. Access to justice can be heavily enhanced by the fact that we could reduce repetitive cases and reduce backlog in courts. We could also create simplified tools that may be less than what you would want from a perfect arbitration or from a perfect court proceedings, but would still be able to provide you with something that will give you some justice. On the flip side, what this also means is that access to justice may be the same as access to technology. We already know since before that if you have money, you are going to have a better defense sometimes. Now that money is going to be able to buy you tech, which may enhance that inequality that you already have in the system. So I would say that it's going to do both, but it's certainly going to change the balance when it comes to access to justice. And the second question, sorry, could you repeat that?
So are these AI judges, when they arrive, going to be better than the human judges we know?
Well, they're not going to be arriving on a shiny horse. They're going to be sequenced into it. And I think by the time that they are here, we're going to be quite used to it, because it's going to be step by step. And it's going to be replacing that part and then that part. And it is going to be a lot better humans on some tasks and a lot worse than humans on others. And hopefully the adaptation and implementation of this will mean that we will use it smartly and enhance us where we're worse than machines. But when it comes to, for instance, drawing analog conclusions and that kind of things, that's where AI is so far not necessarily up to par with human minds.
Okay. So, Minesh, tell us what do we need to worry about? What are the cautionary tales of embracing AI in the manners we've just been discussing?
Thanks, Stephen. I did say at the beginning I was going to be slightly more pessimistic about AI, so forgive me on that. But the first point I want to discuss is actually the difference between AI and automation or other forms of technology. And I think any debate about AI needs to acknowledge what AI actually is. And there's a tendency, I find, to use the label of AI quite carelessly. We call things AI that aren't actually AI, and it matters. Let me highlight a difference. Traditional computing involves giving computers a set of rules. Take a very simple example. On Microsoft Excel, when you ask the computer or the program to reorder cells into alphabetical order, those rules are all set by humans. You tell the computer, look at the first letter of the word, A goes before B goes before C, etc. Humans remain the master of the system. The computer cannot act autonomously outside of those rules. And the reason we do that is because computers are quicker at making the rules, at making the decisions than humans. But to make those rules, humans need to understand the data. You need to understand exactly what you're dealing with in order to tell the computer what to do with that data. Now, the problem in today's world is the amount of data we have. Everyone's heard of the phrase big data. And just to give you some practical context to what that means, it's been discovered that in 2019, in each minute of the day, there were 4.5 million Google searches conducted. And in each minute, there were 700,000 hours of Netflix watched. And possibly more relevant for lawyers, in every minute in 2019, there were 188 million emails sent worldwide. So that's a hell of a lot of data that we're creating as humans. And we can't possibly do justice to that data. We can't understand it so that we can then program computers to digest that data and do things with it. The answer is AI. And the essence of AI is that instead of humans reviewing that data and creating rules for the computer to follow, we ask the computer to review the data and essentially make its own rules. And that's why AI is so powerful. There really are no limits. So instead of programming an autonomous vehicle to say, avoid a pedestrian or turn left at a left sign, what we actually say is get me from A to B. And then we test, and test that AI system until we're happy that the computer has developed its own rules that work for us. But the problem with AI is that these systems become so incredibly complex. You've probably heard of neural networks, which are sophisticated AI algorithms used in systems like autonomous vehicles. They become so complex that humans actually don't understand how the AI is operating. And that leads to two risks. We don't know how the AI system reached the answer that it reached. It's not like a traditional computer where you can go back and follow the rules and understand how the computer arrived at its decision. And the second risk is that you can't always predict how the AI system is going to respond in a new situation. So that's the distinction between AI and, I would say, traditional automated computing. And just taking a step back, Stephen, you asked me in an earlier discussion, doesn't this create risks for AI which may need to be regulated? And the answer is absolutely. These are new, unique risks that we haven't faced before in terms of new technologies. We've developed with AI a new technology that's capable of acting not just in an automated way, but in an autonomous way. And that's why you can hopefully understand my slightly pessimistic view. Yes, AI is capable of massive things. I completely agree with the CEO of Alphabet that AI will be as profound as electricity for humanity. But with all that capability comes risk. Now, the risk profile obviously varies depending on the context in which AI is used. Autonomous vehicles carry a huge risk. It's a risk of loss of life. The use of AI in arbitration perhaps doesn't carry the same risks, but we're still concerned with justice in arbitration. And that's still obviously a very important context. And we're seeing around the world today a retraction of the use of facial recognition in law enforcement. And that is because we're starting to realize that even though AI and facial recognition technology is very powerful, it carries significant risks. And particularly, we're seeing risks of discrimination and bias by AI in those contexts. Now, I'll let the other speakers discuss that risk in more detail in the context of arbitration. But my view is that automation will be used frequently, but that's less risky. The humans are still in control. AI may start to be introduced, but I suspect we're still many years away from the wholesale adoption of true AI into any judicial or legal process, for the simple reason that AI still carries a lot of risks. And just to conclude, it's those risks that are the reason for an increasing focus around the world on a regulatory framework for AI. We need to be able to control this technology from a legal perspective in order to keep people safe. But it's fair to say there isn't actually much regulation today for AI. There's some data protection legislation, the GDPR being a good example, which can regulate how personal data is used in the context of AI. There's also some generic regulation, for example, on product safety, which could apply to AI, but there isn't much specific regulation for AI. Now that's going to change, I think. The EU has recently released a white paper road mapping specific regulation for AI in the EU, and that's likely to come into force in 2021. But that's an isolated example. In the meantime, there is a lot of noise about using AI ethically, which is still a very important topic. Stephen, back to you.
Okay, Minesh, we've had a lovely question in from a very wise participant in terms of the big data debate. What's your view in terms of getting the programming and the coding right first before we then launch into AI procedures? Would that, I think the question's asking, would that resolve one of your risks or reduce the risks in terms of the fact that we would have some security in the reasoning, because the predictability would be we got the coding right? Would that change things?
Some help, and I don't want to get too deep into the technicalities here, but when you're dealing with very complex neural networks, and these are the types of AI algorithms that are used, for example, in autonomous vehicles. There is a camera looking out, or many cameras looking out of the windscreen, processing every pixel that is available in front of it. Humans are not able to code those systems in a way which they then retain control over how the AI system operates. The AI system is programmed to make itself more accurate, and it changes its own nature to become more accurate. And the more complex those systems, the further away humans are from the coding. We can sometimes understand some of it, but we can't understand a lot of it. This is what we call the black box problem in AI. We're unable to lift the bonnet of the model and understand exactly how it's operating. So there's only some respite from being able to get involved with the coding. The essence of AI is that it does it itself.
Okay, thank you, Minesh. And it's always great to start a debate with the positive and the pessimistic perspectives to see where we end up at the end of the debate. Parish, Minesh has very kindly, as always, sort of moved our vehicle of discussion into regulatory. And of course, you represent a professional body, but as an individual, you've been following the ethical framework. So tell us, what is the ethical framework required for AI?
So, I mean, I'll begin with a, thank you very much, Stephen. I'll begin with I guess, a broad definition of what ethics and AI means. I mean, if we take as a starting point that what ethics is what's the right thing to do and what's the good thing to do in a particular situation, then I guess in the field of artificial intelligence, that's obviously begging the question, asking the question, what's the right or good thing to do when it comes to artificial intelligence? And what an ethical framework then does, it gives us a set of principles. We can start at a very broad level by looking at broad ethical principles such as the utilitarian or instrumental view of ethics, which might say, well, what's the best thing to do in this situation? I mean, to put it in Bentham terms, what will maximize our happiness and minimize our pain? And one can take those principles. The ethical framework gives us a set of solid principles, and there's a lot of good people doing some work in this field, and many of them are my friends and colleagues. And we can take those principles and apply them to different AI situations. So I guess a utilitarian might say in looking at data, when it comes to arbitration, when it comes to artificial intelligence in general, what is AI? I think Minesh alluded to the fact that AI draws upon large data sets, and then it's a question of training those algorithms on those data sets. And of course, we have different types of machine learning, reinforced learning, and other supervised and unsupervised forms of learning around data sets. And the more data one has, arguably, the better the algorithm will function. But of course, in the field of arbitration, are things like privacy, confidentiality, and so forth, which often limits our access to those data sets to enable us to really train those algorithms, to enable us to have really good working artificial intelligence. So a question might be, from a utilitarian perspective, at what point do we have to strike a balance between saying, well, actually benefits are maximized by having as much access to data as possible, whilst at the same time we're saying, well, actually confidentiality and similar things are very important when it comes to, for example, maintaining the integrity of what private dispute resolution actually is, and why clients go down that particular road. So an ethical approach to data might say, well, how do we strike that balance between access to data whilst respecting confidentiality, and require us to then develop arguments around that, or develop a position around that. I guess from a deontological, from a Kantian perspective, key questions might be things around bias. My colleagues here have alluded to bias. You know, any system should, of course, we aspire to neutrality as much as possible. Bias does creep in, but we need to minimize that bias, especially in the field of artificial intelligence, because there is a perception in AI that because it's a machine, it's neutral, and therefore there is no bias involved when it comes to machines. And people tend to gravitate towards technology because they think it's neutral and it'll give the best results. But bias can be programmed in, especially at the learning stage when one is sort of training data sets. And so from a more deontological perspective, we want to be able to minimize that bias and prevent those forms of bias from arising, so that what we ultimately have are systems that can enable true prediction and accurate prediction in a way that sort of doesn't lean towards one particular perspective, and really does take into account and judge all of those perspectives from the best position, from the most neutral position possible. I guess as a trainer, ethically, again, talking as a canteen, I'd say looking at skills. The key question in the domain of artificial intelligence and especially legal technology is, what will this machinery do to graduates or those who are entering the profession in the future? That's obviously a key question for us to consider. And certainly that's something which I'm quite cognizant of, thinking about the skills around artificial, around technology, and what sort of duties and responsibilities do we have in terms of training people and training professionals for the future who are entering the world of technology. And there's other things around security and sort of access to justice, which I'd be happy to talk about as well. But that's essentially what an ethical framework is. It's setting out those principles and sort of guidances within the field of AI to judge what's the good and proper use of AI.
And I imagine, Paresh, in the midst of all of this, you've got data access issues, you've got security issues, and those are probably resolvable, but actually, you know, in terms of ethical frameworks, there could be EDI concerns. How do we address those?
So there are security. I go back to what Minesh was saying about the distinction between technology and AI. Certainly in the pandemic, we've seen people having to revert to technology more broadly, Zoom or Microsoft Teams and so forth. And of course, that raises security concerns as a natural rush to technology because of the pandemic. And certainly when it comes to arbitration and legal practice in general, law practices they have to be sort of hives of data. They hold massive amounts of data from clients. And so therefore having the security protocols in place is obviously very important. Artificial intelligence can actually help with sort of cybersecurity issues. I mean, IBM, for example, IBM Watson, which leverages deep learning in sort of in machine learning. And Microsoft have a great project around using artificial intelligence to help with cybersecurity, where what the system does, it trawls through massive amounts of data sets to spot those sort of malicious forms of threats, and so that when those who are using these IBM systems are you know, the system monitors the traffic and spots any vulnerability. So artificial intelligence in the field of security can be a great help. In terms of EDI, equality, diversity, and inclusivity is something which we're very passionate about at the CIARB. The key question is technology, is artificial intelligence equalizer? In this respect, I mean, one of the questions which I'm often asked as a trainer is, okay, you're training us, how do we get our first appointment? How do we get our experience in arbitration? And often it can be quite difficult to acquire the experience that one needs. It often becomes like a vicious circle. And certainly that's something that we're very keen on promoting career development and giving our trainees guidance on how they can develop their careers. But the question is, does technology actually, is it an equalizer? Does it enable new players to enter the field via another access route that they might not have via the traditional routes of getting appointments? I mean, certainly in the litigation space, what we've seen an influx of startups and computer scientists and others who've come in and disrupted the field, and whether for better or for worse. But what it's done is it's enabled a new actor, a new set of actors to enter the legal space and provide their services. And the question then becomes, within the ADR and arbitration space, might there be room for those who might not otherwise, you know, have access for whatever reason to the traditional forms of appointments, to kind of come into that ADR space for a different route via technology? And might that level up the playing field? Might that equalize the playing field and enable a greater pool of people from across the world to enter the ADR space? That's an important question to ask.
Okay, and it's an absolutely fascinating debate. We've had one quick question in. How do we minimize the bias?
That's a question I often, so I'm part of a circle of philosophers in looking at philosophy and technology. That's a question we often ask ourselves. And from one perspective, can one ever eliminate bias? We live in a dialectical world where we'll always have one person will have their view and another person will have their view. And it's just the nature of things that there'll always be bias. one could argue, in every context, because it's always a difference of perspective. And so what we often say in this circle is that bias is an inherent part of human life, but because we are all different, and that's where ethics comes in. If we were all the same, if there were no biases, and we all had the same thoughts and ideas, there'd be no need for ethics. Ethics is there because it's an equalizer between us and the different biases that we hold. So how do we minimize bias? It's by having a strong ethical and regulatory framework to ensure that any sort of issues around bias or differently, sort of minimize those. And in that respect, there's been some very good things done recently. I mean, certainly in the field of criminal justice, where there's been accusations of bias against many sorts of algorithms and technologies, we've seen a very strong ethical and regulatory framework starting to build up. So two things: can we ever eliminate bias? Can we minimize bias? One might argue no, but of course that's something that we aspire to, but then it's important to have a strong ethical framework.
And I suppose what's just struck me actually is the fact that we talk of bias, but there's also unconscious bias. So there's another layer to think about ethically.
Yeah.
Thank you, Paresh. Tom, given all these concerns, you tell us, we now move to practice the reality of the situation. How do we successfully run and reason an AI arbitration?
Thanks very much, Stephen. Lots of interesting issues. And I think the short answer to your question is that these proceedings, at least for the foreseeable future, are not going to be run and reasoned much different from how they already are. Because I think the way AI is going to work itself into practice, and is starting to work itself into practice, is sort of around the edges and not necessarily through the front door. I think one of the ways that AI will start to work itself into arbitration proceedings is as a result of its predictive capabilities. We're probably all familiar with the studies that have been done on decisions of the European Court of Human Rights, the US Supreme Court, and others, where the results basically say that AI programs can accurately predict the outcome, say 70 to 80% of the time, whereas humans get it right maybe in the high 50s, right? So AI is better at predicting outcomes than humans are. Well, does that necessarily mean that AI should be used to decide cases, whether it's court cases or arbitration cases? And I have to say I'm in the same camp as Lise. I think the answer is no, we're not going to see AI arbitrators or judges anytime soon. I think an interesting statistic that reinforces this point is the results of the 2018 Queen Mary survey, where they asked people participating in the poll whether they've used artificial intelligence in international arbitration. And 53% of the people who responded said they have never used it. 15% said rarely. 20% said sometimes. 5% said frequently, and just 3% said always. So not many arbitration practitioners are using it as things currently stand. And I think what's interesting about this, and it goes back to a point that Minesh made, is that when you look at the survey, it didn't just say artificial intelligence. It said artificial intelligence, for example, data analytics and technology-assisted document review. So the people that were responding to this probably thought they were using AI, but weren't necessarily doing so. So that suggests that the numbers are even lower. So again, I think it's going to be the predictive capabilities of AI that we see when we're running our arbitration cases, and how is that going to manifest itself, especially in the short term. And I think in areas like settlement discussions, I think you may start to see law firms and parties using AI programs to try to anticipate the strength of their case, what position they should take during settlement discussions, how much they should push the other side. I think another area where you're going to see it over time, and Lisa already alluded to this, is with third-party funders. I do think that is a group in the international arbitration community that will probably start to embrace AI probably sooner than others. You know, I had an interesting experience in this regard a couple years ago. We had a client that was seeking funding for a case. We approached one of the funders. The funder said, we will take the case on if there is a 60% chance of likelihood of success. And so they looked at the case, they analyzed it, they brought their own outside law firm in to assess the merits of the case. And that law firm concluded that there was precisely a 56% chance of success in the case. And we sort of scratched our head and we said, well, wait a minute, how can a bunch of lawyers come up with a chance of success that is that accurate? You know, it's either 50% or 75%. It's not 56%. But what's interesting to me is that if an AI program would have said you have a 56% chance of success, we probably would have bought it. So I think that's an example of how maybe as practitioners we do accept the results of technology more than human beings sometimes. I think over time, another area where you can see AI coming into the arbitration process is, and probably have to be a little bit careful here, but I could see arbitrators using it to check the outcome that they think they will reach in an award, kind of using it as an assistant. I think that's probably further down the line, and I think it raises some concerns. You know, is it the arbitrator deciding the case, or is it the AI program? But I think if an arbitrator has an outcome that he or she thinks he or she's going to reach, and sort of uses AI to check it, that may be a use. I think another area where we're going to see the use of AI in arbitration proceedings very soon, well, relatively soon, is in the selection of arbitrators. And there's already efforts underway in that regard. Arbitrator Intelligence Ai, not to be confused with Artificial Intelligence AI, is an initiative that's underway that's moving in this direction. Right now, it is not, Arbitrator Intelligence is not artificial intelligence. Arbitrator Intelligence is basically aggregating data about international arbitration awards and analyzing that data to make it available to users of arbitration to help select their arbitrators. Now, this touches on some interesting issues because I think Arbitrator Intelligence is trying to overcome a related issue that I think it was Paresh was alluding to, and that is the challenge in international commercial arbitration of getting the data, getting the results from awards, because a lot of the awards aren't available because of confidentiality. The way Arbitrator Intelligence is addressing this issue is sort of twofold. Number one, they are trying to aggregate the awards that are out there in the public domain as a result of enforcement proceedings or in cases where there were not confidentiality provisions in place. But also what they're doing, they have these, they're called AIQs, or Arbitrator Intelligence Questionnaires. And these are questionnaires that are intended to be completed by parties, counsel, and at the end of an arbitration that have objective data about the award. So what was the amount awarded? Was document production ordered, yes or no? Things like that. The idea is that this is objective information that can be aggregated in the database but doesn't impact the confidentiality of the case. And the idea is that over time, this database will be large enough and can be applied to an AI program. And so I think we will see AI start to emerge in that area, and I think this will become commonplace in international arbitration proceedings. I think the other area, another area of the arbitral process where we're going to see AI creeping in, I think we're already starting to see this in court proceedings, especially in the US and the UK, and that is in document production and the use of predictive coding, where you have human lawyers review a small subset of documents, designating certain documents as responsive, non-responsive, relevant, non-relevant. And my understanding is the sample size can be as small as, say, 2% of the overall document size. And then this information is plugged into the AI program. The AI program can basically analyze the rest of the document. So I think that will save a lot of time and costs. I think probably another area is more practical, probably more having more of an impact on the proceedings themselves, is in the area using speech recognition to for transcriptions and interpretations, probably even real time. I think there's a lot of other issues I could touch on, but I think just one more thing I'll mention, and that is reasoning. And I think a couple of the other panelists have already touched upon this. If we start to get awards that are determined by AI program, I mean, those awards are going to basically say the claimant gets X because there is an 85% chance that the claimant would get X, period. Right? And it's not going to be supported by reasoning. And is this going to be acceptable? Is this going to be acceptable to users? Is it going to be acceptable within the legal framework? Obviously, there are going to be challenges here. It's going to be difficult for the losing party to understand why they lost, other than there was a high chance that they would lose. So I think this is where it can create some difficulties. I think for small repetitive cases, it's not such a big deal, but certainly in larger commercial and investment cases, it will be a challenge. Parties can always agree under the unfair trial model law, for example. Parties can agree that the arbitrator does not have to issue an award with reasons. But I think in practice, this is going to be a big hurdle.
And that's a vast area to unpack quickly, Tom. Just to pick up a few points, because we've had several points in on this. The first point, quick answer. So calculating sort of remedies, is that just going to be a pure computer calculation?
That's a good question. I think the short answer is probably not, or at least we're a long way from that. And I think it's going to go back to these issues of, are the parties going to be satisfied with a computer saying you've got an 80% chance of getting this amount? And if you look in practice, I mean, quantum and damages are not a straightforward exercise, right? You get competing experts that have different opinions. And so I think we really are a ways off from that.
And a beautiful segue to the next question raised by one of the participants. Usage of expert witnesses. Anil might deal with this in a moment, but in your experience, Tom, how do you think they're going to manage using experts in an AI system?
Yeah, another very good question. And here again, I think it goes back to what I said at the beginning of my remarks. I just don't see these big changes right away because, in each case, the parties are going to argue that somehow their case is different from the data, from the other cases, from the data being used to create the algorithms in the AI program. And they're going to say, they're going to exercise their right. They're going to say, I want to bring an expert in to explain why it's different and why you can't use the AI program in my case.
And what's interesting about that is there's several people have chatted in terms of moving to analog to digital. So you described at the beginning, you wouldn't see much of a difference moving to AI. What is the difference of going from analog to digital then for AI arbitration?
I'm not sure. I think
I'll let
somebody else take that one.
It's a discussion for all of us, I think, because that's such a pervasive question in terms of, what will it look like? What will it have from the past? What will it be different moving forward? And that's what this whole discussion is about. Last point to you, Tom. So you've excited too many people, I'm afraid. That in terms of process or program, when you do an AI arbitration, is there going to be any considering, any reasoning in the process, or is it pre-plugged, pre-planned?
Yeah, I was talking to somebody about this morning. I think, I can envision an AI arbitration that is largely automated, so to speak, for these sort of non-complex, low-value, repetitive sorts of claims, where you basically have a claim form or fields that you fill out on a website, you put in the data, maybe some supporting documents, that goes into the AI program, and the algorithm produces a result. But it seems to me that even in those cases, you need someone, and I don't know if you call him or her an arbitrator or an arbitrator in quotes or a referee or what, but to resolve issues, procedural issues that come up. One of the parties submitted a document. Is that document admissible or not? Maybe in time the AI program can decide those issues, but I think inevitably there'll be some issues that need to be decided by some human being. And so you've got to at least have someone available, even if they play a minimal role, to make those decisions. Other panelists may have different views, and maybe 100 years from now it'll be different, but that's kind of where I come out.
Okay, thanks,
Stephen,
Tom.
Can I just add to that?
Of course.
Completely agree with Thomas that it would only be small cases that are capable of being resolved by an AI judge. And actually, Estonia is currently trialing a system for very small cases, up to, I think, 6,000 euros. But exactly as Thomas said, very straightforward cases, very few documents, no need for human qualities like empathy or other emotions to be able to properly decide the case. I'm not sure whether it's true AI. I think that's just very sophisticated automation. But it's an interesting example, I think.
Well, that would have been my comment. So just picking that up, Minesh, in our prelim discussion before I hand over to Anil to talk more about AI and practice. So picking up your last point with the point that you made before, Minesh, how much of this is going to be algorithm pre-planned then? So I'm not suggesting the Estonian system is, but if it's low level, low volume, doesn't it input a algorithm characteristic? You know, the neural system will be one of 75 different answers. Is that what we're talking about?
Exactly right, Stephen. So this is more likely to be a human-programmed, very advanced automation system where the computer is programmed to recognize, as you say, potentially 75 different types of claim or arguments or responses, defenses, and then it just processes the claims much quicker than a human could. True AI is very different to that. True AI can exist, and it does exist in a couple of cases already in dispute resolution. Thomas alluded to those. In document review. So there are sophisticated machine learning systems now that categorize documents and understand documents based on what humans tell the computer about a very small sample of documents. I use those systems every week. They're incredibly powerful. And in natural language processing, which is quite a big part of machine learning, that's already being used as well. They use it in China in the court system to automatically transcribe cases. That's another interesting example of true AI. But you're right, the majority of these systems are sophisticated automation.
Okay.
Thank you both. Sorry,
of course,
may I
Louise.
also add a comment? So one thing I was, I'm kind of wearing the hat of the optimist, and even though I also see risk, I kind of like the hat, so I'll keep wearing it. But the one thing that I'm picking up as well is I've heard alluded to here, and also in previous discussions like this, that lawyering is not an exact science. So if you ask 15 different lawyers a complex questions, you're going to get 15 different answers. Now, to me, that begs the question, is that really the mark of quality? If I go to 15 different doctors, one tell me I have cancer, another says I have a headache, and the third one says go and have a lay down and you'll be fine, I'm not going to be happy with that. I would like to have more predictability than I would say that human lawyers today offer. And so for me, that kind of continuously, when I listen to the risks that are being listed here, we also need to keep in mind, how good are we at this today? Are we actually as good as we think when it comes to being non-biased, transparent, predictable in how we rule and how we assess cases? And I would argue that if we're worried about replicating human bias in AI, then we should really take a look at if we could use AI to wash out human bias. And I'm not saying that it's easy, but I'm saying it might be easier to retrain AI to not be biased than it is easy to retrain humans to not be biased. And I know that there's a ton of other issues, and there's correlation and causation and all those kind of issues as well. But we need to maintain an eye to the baseline of what do we have today and how perfect is that?
Well, I totally agree, Lise, but I also think that the baseline is, as I say to all my students and have done for 3 decades, that law is not an exact science. And when the student asks, why is that, professor? I respond, because the lawyers like it that way. Simple as. So turning to a learned friend, Anil, in your experience, tell us, how does AI work, and particularly the legalities and the decision making, because there's been lots of concerns about that so far on today's panel.
So what I'm going to do is this. I'm going to give a quick brief on what ADR and arbitration are and the process, and look at some of the aspects of AI and how that could apply in arbitration. So we start off with this. Liz said, we are far away. We are quite far away from AI taking over. So keep that in mind. Keep also in mind that Manish said that, you know, there's a difference between AI and automation, and it's about where it involves digesting the information. Paresh talked about ethics, which is the end of what I'll be speaking a little bit about. Thomas spoke about predictive. And whether or not you can look at settlements, right? And whether you can use AI to predict settlements, the decision-making process, and concerns about whether you look at quantum and damages and all of those things. So what I'm going to try and do is this. I'm going to try and tell you that because it's so far away, how can we get there? What can we do, and what can we turn into AI-aided dispute resolution mechanism? So to start with, let's just take a quick look at what dispute resolution is, right? I call it appropriate dispute resolution because it's no longer alternate. It is what is appropriate. You have 2 main types of it. You have consensual dispute resolution, which is conciliation, negotiation, and mediation, where the parties themselves come to decision. Or you have adjudicative dispute resolution, which is neutral evaluation, expert determination, dispute boards, adjudication, and arbitration and litigation. Now, when you're talking about using AI technology, I would think it's more for the adjudicative approach, because if it's consensual approach where you're mediating a settlement, you really want to be personal about it. You don't want in the AI telling you, now I predict that this is the way it's going to go, and please decide according to that. So let's leave out consensual adjudication dispute resolution and focus on adjudicative dispute resolution. Now that I've framed what dispute resolution is, what are the processes that you have in adjudication? You have, first of all, you have how you formulate your case, your defense, and you frame that in a statement of claim and a statement of defense and so on. And then you have this evidence gathering that involves both documents, putting your documents together, which a lot of the speakers spoke about. There are systems in place that can expedite that in a review of our documents. I'll speak a little bit about that. But you also have witness statements that you're putting together, the facts of the case and so on and so forth. And then you have all of this being presented at the trial, at the hearing, right? So what can AI do when you're dealing with the hearing? And of course, at the end, you have the decision making, where in adjudications, they're called decisions or determinations. In arbitration, they're called awards. In court cases, they're called judgments. And how do you enforce those decisions? There are some aspects about enforcement, but we don't need to look at that. So you have all of this process. So then what you want to do is this. How can AI sit in all of these processes, and can it help and aid arbitration or any other dispute resolution mechanisms? Now, some of the speakers have spoken about this. I'd just like to highlight a couple of things on the kind of technology that's available in AI. But before that, my summary of what AI is a simulation of human intelligence in machines that are programmed to think like humans and mimic their actions, including learning, reasoning, perception, problem solving, and continuously evolving. So that's the framework of AI, right? Exactly. I think Manish had spoken about this, and it's not just about automation. It's about intelligence not by humans, but by machine. So how can you then put that into place, right? And then some of the things that you need to remember about AI and related to our AI is this thing about algorithm, artificial neutral networks, big data ecosystem, deep learning algorithms, natural learning processes. These are things that are related to AI that if you go and learn about it, you may start to see how it might work in dispute resolution. And also you have things like augmented reality and virtual reality. It's an area that I've been looking at a little bit in terms of online dispute resolution. You know, you have this thing about online dispute resolution, but can you put the people and the parties in an environment that like they feel that they're in the same room, right? And that's where these things about augmented reality and virtual reality comes into play. Whether or not that is strictly artificial intelligence, or it stems on a little bit more of technology and virtualness and all that, you know, it's left to be discussed, right? So if you then look at some of the available systems in place. I mean, we talked about automation and documents review, but it's no longer just about documents review. There are systems in place that can analyze these documents, categorize these documents, and sort them out in heads of claims or damages and all of that. So you have some examples are there's something called an arbitration engine. It's an AI arbitration, which allows visitors to either experiment with pre-made scenarios and so on. So that there's a platform that allows that to be done. There's a system called DISCO, which employs cloud tech to conduct document search of a large data. So that's really a bit of an automation style. But there's another one that's called Everlaw, which uses predictive coding to look into the contents and the metadata of the documents provided by the users and classify those documents. So in major arbitration matters, you'd find that something like that might be helpful. Whether or not it stems on AI, it's something that we can leave for our discussion in a short while. You have Kiara, which is an AI that can read the contract and underline important terms and all that. So, you know, contract review, it becomes a critical issue in some arbitrations, whether or not there was a contract in place. I'll give you an example of that in an arbitration matter that I had, and a few other things. So there's something called roles, and there's something called Trin, which is an AI-powered automated transcription software that transcribes and all that. So I've just briefly told you about what dispute resolution mechanisms are, and then I've told you a little bit about the AI-related technology that's available. So looking forward, what do we think we can use them for? I mean, of course, there's also a part about blockchain and smart contracts, which we can talk about in the Q&A. But let's try and put this in construction, for example, construction arbitration matters. First of all, you need to decide how do you frame your case. Now, it's a whole lot of documents that are involved. I'm now in a moment involved in a construction matter where I've been working for a year just setting out the case for the client, and we still can't formulate what the cause of action is because we're all over the place. So in construction matters, we have something called a SCOT schedule where we set out what the claimant's case is, what the respondent's case is, and what eventually we are going to take and cross-refer that to documentation. Question is this: whether or not there is AI technology or AI technology can be developed to try and analyze this so that you can fix it up and get clear answers as to where your cause of action is. So that's one aspect of it. Now, when you come to documents review, of course, in construction matters again, or large-scale investment treaty arbitrations where it might involve a whole lot of documentation, how do you go through and review them, and how can AI help that? Now, one quick example on that, I had a matter where it involved 2,000 or 3,000 documents, and it was kept with the police force because there was a criminal investigation. We then got the police to allow us to take the documents, and we started reviewing them. I had loads of people coming and saying, we've got automated systems that can review your documents. But by God's grace, I had 4 interns for a 6 months period in my office. And we sat down and analyzed it because we had half-page handwritten documents, full-page typewritten documents, full-page PDF documents. There's no way a computer could just analyze that. And amazingly, a claim that was against my client for about 5 million, we realized at the end of that review that we had overpaid the claimants by about 3 million. And so we then redrafted our pleadings to show that. So that's another issue of how you do. Then let's get into the hearing itself, or preparation for the hearing. In an adjudication matter that I dealt with in Malaysia, the timelines are very different. They had 45 working days. And I had to put that out in a table and calculate when exactly, at which stage, what am I supposed to be doing. And it was just a Word document, and we keyed in the dates. Now, of course, that can be automated, but slightly more than automated, can it use artificial intelligence to analyze and presuppose dates that are not to be accounted for, dates that are to be accounted for, what I should then be doing at each of those stages, and generate the required documentation. You know, it could stem between AI and automation. So it's a difficult question to consider, right? And then at the hearing, you have a whole lot of things: transcribing and decision making. And let's talk about expert witnessing. Again, in an arbitration about 6 years ago, we had the arbitrator sensibly told the experts to come together and come with a common report, one single report. But amazingly, what happened, not amazingly, it was quite crazy. The parties, the experts were allowed to rebut that combined report. So they had a report that was in black and white, black print. And then they had the claimant's expert who produced this joint document. The claimant's expert had in blue text their comments on the joint report. The respondent had in green text his responses to it. And then they each had replies, one in purple and one in blue or red or something like that. So it was absolutely confusing. So the point of the matter is, why then did you have to come to a single report, right? So the question then is whether or not there is AI technology that can gather this information, analyze the information by both the expert, and come up with a combined report that balances both of this. Now, then the question of biasness and all of those things, I think if it's somewhat automated and put in an AI platform, I think it takes away the biasness, it takes away the emotions and so on and so forth. And then that leads next to the last part about decision making. I'm afraid, I think that insofar as decision making is concerned, it is not something to be analyzed with algorithms and propositions, and then, like I think Thomas mentioned, the European Union Human Rights and US Supreme Court had talked about the accuracy of 70 to 80%, whereas humans were coming down to 50%. My problem is that I think in decision making, at the end of the day, it is not the mathematics of it. It's not exact science, as Prof, you've just mentioned, that you repeatedly mentioned. So it comes to a level of personal. It's not biasness. It's an experienced arbitrator balancing everything together. So question is whether or not that can be aided with artificial intelligence. Leading up to the decision, I think you can have artificial intelligence assisting you, but ultimately the decision making would have to be a human touch. And it comes back to Manish's point about what Lithuania is doing with small. The reason for that is it's a simple, small issues that can really be decided one way or another, right? Whereas in a complex matter, it's going to be far more difficult to do that. So in dispute resolution, these are the concerns you have. These are what's available, and you might want to see whether or not it can aid you. But ultimately, some point in time, the decision has to be human, and I think we are so far away from artificial intelligence being able to take that on, right? And that's it.
We've had several points raised, Anil. They distill into one point, that what you've described, whether it's sophisticated or unsophisticated, works well in the developed world, but could any of this work in the developing world? In other words, will there be an AI divide in terms of practice for the haves that have and the have-nots that will not have?
Okay. I suppose two parts to that. One is how far advanced are those countries insofar as technology is concerned, or reaching out to the technology with Wi-Fi and all of those kind of things. So it stems on that, right? So that's one aspect of it. The other aspect of it, I must say, is very much cultural. Let me explain why. you know, when last September we had the Singapore Convention on mediation, and it was passed, and everybody was up and, you know, excited about it. Me as a mediator, I felt that, you know, I don't see why you need an enforcement mechanism in mediation, because mediation is what two parties come together and decide and they settle, right? So and what are the chances of them defaulting on that settlement, that you need to resort to a convention? But interestingly, a lot of the developing countries have got incredibly different views about mediation. Mediations are used as a mechanism to stall. Mediations are used to take the one party down a different path, and crazy. So I think using that aspect of culture and all that, this question is really complex in the sense that you really have to, fundamentally technical aspects, it depends on the developing countries, whether they've got the infrastructure in place to use that thing. But bigger than that is a cultural issue of whether or not they want to go down that path, whether or not they rely on that path. And it comes back to the issues that Paresh was talking about, ethical concerns and legalities of it. So it's not a very easy question to tackle. But yeah, I must say, with technology moving the way it's moving, we'll all be on the same level playing field eventually in terms of the resources and being able to use technology. I think the world over, everybody's going to be on par as far as that's concerned.
And I'm sure we'll come back to this important issue. Paresh, you're going to say something?
Yeah, I just want to pick up on one point, one ethical point that comes out of what Anil just said, that on decision making. I mean, as humans, when we make decisions, we are accountable for our decisions. Of course, we weigh out various factors in reaching what we think is the best decision in a particular case. When it comes to artificial intelligence and technology, who bears the responsibility? I mean, if an arbitrator, if a judge is using a piece of technology that's been designed by someone else, and it's certainly within the field of predictive analytics, and they're sort of drawing upon that information and they're relying upon that information, does that then mean that the responsibility for that decision making doesn't solely rest with the tribunal, with that arbitrator or judge, and that the technology company has some responsibility as well? And that's especially important in terms of attributing responsibility, attributing blame even, and it might even sort of spill out into the field of liability as well. If something were to go wrong, who'd ultimately be liable for that? Certainly with lawyers using technology, if their clients were to want to sue them, where would that line of liability lie? Would it lie with the lawyer who ultimately used the technology, the user, or would it be with the developer who develops it? So there's sort of ethical issues around that, which I think are important as well.
Well, I think they are very important questions, and I suspect Anil and I will agree that those questions will be determined on a case-by-case basis. But I suspect, because there is much discussion at the moment about the liability of the tech companies, that this is a very important issue for tech, for law, but also for the so-called courts, or in this case, arbitration dispute resolution schemes. Because I suspect the third-party involvement is more critical in AI than in other areas currently operating at the moment. So if we may, we're going to move to Thomas now and the big picture. Thank you, Anil, very much. Thomas, the bigger picture, we've talked about then AI as a tool, but does it truly work to resolve disputes to fulfill its purpose?
Thank you. Thanks for the question. So we've had some great speakers, and as I mentioned at the outset, I'll now have the opportunity to draw some of those points together. And I'll pick up on a few points, but you may hear in my comments, particularly some ideas responsive to Lisa's comments and to Tom's, but my comments follow on nicely from what we heard from Anil. And the structure of what I intend to cover is as follows. First, I'll touch on how the pandemic has resulted in the introduction of novel ADR approaches. And then I'll make the case for robot arbitrators and how the current environment is well suited for them, which is a potentially controversial proposition. So perhaps we'll have some nice discussion around that. And third, I'll conclude by proposing a system of med-arb, whereby a human neutral works in parallel with a robot arbitrator. And that's just a concept of mine that I've cooked up, and we'll see how that plays with our panelists and the audience. So my starting point is that AI, as well as technology in general, is seen as having great potential for efficiency and time and cost savings in arbitration. And you heard Tom reference the 2018 Queen Mary survey, quoting some statistics on AI. I'm going to quote some other statistics on AI, which are more favorable to my case, which is that 78% of respondents indicated that AI is a tool we should use more often in arbitration. And of course, even higher percentages of respondents were in favor of video conferencing, cloud-based storage, and hearing room technologies, 90% and above for each of those. And we see that in the current pandemic, those technologies, with the exception of AI, have now become very quickly ubiquitous tools in the arbitration world. So in parallel to that, the pandemic has led to calls from jurists around the world. And indeed, in some jurisdictions, there's new legislation on this point, which is aimed at reducing disputes between parties and avoiding breakdowns in global supply chains. For example, in Singapore, it's called the Singapore COVID-19 Temporary Measures Act 2020, provides that instead of court proceedings, disputes should be resolved by independent assessors issuing binding determinations. And those are informed by the financial condition of the party seeking relief. And those determinations seek to achieve an outcome that is just and equitable. And in those proceedings, parties don't have legal representation before the assessor, and there are no cost orders. In the same vein, but it's not legislative, it's merely a guideline or a concept paper, the UK BICL, the British Institute of International Comparative Law, issued a note titled Breathing Space. And Stephen, this is something you and I discussed in our pre-call, which advocates for the use of ADR to encourage negotiated solutions to disputes wherever possible. So in the commercial context, businesses may be less concerned with issues of justice and fairness and more interested perhaps in just getting a quick resolution to their disputes so they can move forward. And as we'll see from the next few minutes, that might be, in the case of an AI-assisted dispute, something that is achieved in a matter of days or even hours, rather than months and years in the case of traditional arbitrations. So it's in this context of the pandemic that I start to revisit the concept of AI to assist in resolving disputes. And we've heard previous commentators talk about what it is that we're talking about when we say AI. We've heard about data analytics, technology-assisted document review, and there's obviously a future for those tools to be integrated to the extent they are already integrated, and we'll see more of that. But a more ambitious and far-reaching vision is actually the AI arbitrator or the robot arbitrator. And we've heard already about the possibility of using AI to support parties in making their case and in helping parties determine whether they should settle. If we think about the robot arbitrator, that's a structure where the arbitrator would have access to documents from both parties. And if that system were used consistently, that AI system would have access to previous disputes and awards it had rendered, and that would lead to more informed awards. And it would also lead to consistency of awards, which is an area in the arbitration discourse where the arbitration world is frequently criticized by litigators, that it's a closed system, confidentiality of awards doesn't allow for a system of precedent to be established. But this system might help bridge the gap. And at the same time, the robot arbitrator would maintain confidentiality because it is a somewhat closed system. So you wouldn't have the current kind of middle ground is awards which are sanitized, being published from time to time. If the parties agree, if the institution has the rules which allow for that, you would have this system within an AI, within a robot arbitrator, which would both help to maintain consistency of awards and confidentiality at the same time. And a further benefit is that an AI-assisted disputes process like a robot arbitrator could help to preserve the relationship between the parties. So we can imagine that instead of drafting aggressive pleadings which attack the other side and their conduct, parties would be focused on finding the most useful documents to support its case and submit those to the robot arbitrator. And then in a relatively quick manner, the parties could obtain a resolution and move on with their relationship intact. And perhaps in contrast to some of our previous panelists, that could actually have a very significant impact on the way in which arbitrations are conducted and submissions in particular. It might mean, in fact, that there's a certain equality of arms that's been achieved, and it might lead to greater access to justice. And we might pick up on that point in respect of developed and developing legal systems and jurisdictions. So moving on to kind of how this looks in practice. There was an article in the FT last year which addressed the possibility of using an AI mediator. And that article noted that in a first for the courts of England and Wales, there was an AI tool called Smart Settle One, which actually acted as a mediator in a dispute in the online civil money claims court. And in less than an hour, using a blind bid mechanism, that tool settled a 3-month dispute over a £2,000 unpaid bill. So of course, that's the small kind of dispute that we've been talking about as a good candidate, perhaps, for an AI system. That same article concluded with a quote from a friend of mine in the arbitration world, which noted that the mediation process is inherently a human one. And I've recently taken a course to become a mediator myself to supplement my arbitration practice, and I would agree with that assessment, particularly regarding the need to establish trust between the mediator and the parties. And we've also heard about the points of bias, which were addressed especially by Minesh and Paresh, about humans not being immune from bias and AI not being immune from bias. So we have the bias issue to deal with as well. And that brings me to my third and final point. Does the robot arbitrator need to replace a human? So I'd submit that a human is a necessary part of any complex dispute, but there's potential for us to work side by side, particularly where we consider the framework of MedArb or ArbMed. And that's a hybrid mediation arbitration process, for those who are unfamiliar, where the same neutral acts as a mediator to mediate dispute, and then as an arbitrator to arbitrate the dispute and issue a binding award. And that process has been specifically recognized in the arbitration law of some jurisdictions, which recognize the authority of tribunals to conduct a conciliation during an arbitration and to issue a binding award to give effect of any settlement. So if we envisage a process where a human neutral works in parallel with a robot arbitrator, we can see how the drawbacks of a purely AI system might be mitigated with human involvement. Equally, we can imagine that an AI-assisted procedure would be conducted much more quickly than is currently the case in a humans-only arbitration. So under that system, the one that I've kind of submitted or put forward, the arbitral award would be rendered by the human, and this would hopefully not give rise to issues of enforceability and minimize some of the ethical concerns. Touching on some of the comments raised earlier, that ethical concern hasn't yet been extensively discussed by national courts, but we have one example, at least. In 2016, the Wisconsin Supreme Court considered whether a judge could properly use a tool to predict the probability that an individual would be a repeat criminal offender. That's Wisconsin v. Loomis. And the court found that the judge had used the tool for information, but he had made an independent decision regarding what sentence would be appropriate for that individual. And in 2017, interestingly, the US Supreme Court declined to hear that case. So that's currently good law in the US. So with that, I'll conclude, and I look forward to your comments and questions. Thank you.
Thank you, Thomas. A lovely summation, but interestingly, some more, innovative thoughts in terms of the way we're going forward. So there's immediate questions that come up in terms of, during the pandemic, we've had a move to remote courts, virtual hearings very quickly. So post-pandemic, how will that impact upon the sort of speed at which AI is more utilized in dispute resolution?
Well, I think that opens the door. So previously, there might have been a resistance to having remote hearings and virtual hearings and making use of this wonderful technology that we have. And now we've had no choice but to adopt it. And I think that as people become accustomed to using this technology, it will really encourage people to look further and see how else they might incorporate more innovative approaches like AI. Okay, thank you. Right, so we've got plenty of time now for our Q&A session, as I promised. There's 4 big issues in already. So
So panelists, help us with this. No regulation. Should this be an area where there's global regulation, such as the WTO? Who wants to start with that? Anil.
Yeah, so, on online dispute resolution, United Nations in 2016 had a protocol and a framework set in place, but they had not moved that any further. APEC last year met in Osaka. I was part of that. And they've set out a framework and protocol for online dispute resolution, and they've passed that, and then they're going to move forward. So my take is that you really need to put that in place. And the question that you had asked Thomas last part, coming out of the pandemic, what you're going to see is this: with a whole lot of regulations, protocols, and directions given by different institutions on how online dispute resolution should be dealt with, I think what you're going to see is a little bit more and more AI-related regulations and framework being put into that structure. So, it's going to be a slow process, but you're going to find certain things like, so for example, they talk about online dispute resolution, and then there are these protocols, then they say, okay, so for documentation, this is what you want to use, these are the softwares that you want to use, this is how you're going to want it to be analyzed. And to speed up the process, you don't really need the parties and the lawyers reviewing it. You can use this software that analyzes it and categorizes it. So you start to see a little bit more coming into play. That's what I think it's going to happen.
Okay. Do we think that a global regulation would change the ethical framework, Paris?
Sorry, muted.
Amateur mistake there. So apologies for that.
It's okay. Do it all the time.
So when it comes, okay. So when it comes to global frameworks, of course, it's an interesting one because leveling that playing field, taking into account we have different speeds at which people are adopting technology, and obviously they're coming at it from different perspectives. I mean, when we talk about sort of international instruments, say for example the New York Convention, I mean there is some sort of level playing field there, and a recognition that we want to be able to enforce awards across the world. When it comes to technology, of course, different countries are adopting it different ways. There's not universal access to technology. There's different legal systems and different legal traditions involved in the application of that technology. And at the moment, I don't think that although we need regulation, are we at a stage at the moment where we can sort of need that on a national scale, on a regional scale, or on a global scale? Given that there are differences of approach towards the adoption of technology, and I guess it's such a new area at the moment that the field hasn't really settled for us to be able to say, well, these are the definitive risks on a universal scale, and therefore here's a universal piece of regulation. I think that what will happen, it will evolve from the ground up, where we will start seeing national frameworks and possibly regional frameworks. Someone alluded to, for example, the European Union, and then eventually we'll get to a point where they'll be global, because at the moment I don't think we have a level playing field.
Okay, and that leads neatly to another big question, another big issue, which is, what do each of us think as panelists in terms of the cultural change required to put faith, 100% backing support into an AI system for arbitration?
Prof, I think that's a very, very difficult question to answer because cultural differences are amazing. I mean, just last week I spoke on mediation, cultural differences in mediation in Vietnam. We had a speaker from Japan who told us about the culture there, a speaker from Korea who told us the culture there, a speaker from Vietnam, and I spoke about Bhutan, India, Indonesia, the cultural differences. So, trying to balance all those cultural differences in mediation is one thing, but to come up with and decide, how someone looks at technology, it varies across the world, all over. Yeah. But having said that, you must also realize this: the pandemic has put everybody in a similar situation and in a similar platform. So you are going to find certain aspects of maybe health, technology, all coming up to speed equally across the world. So I think a lot more people are going to be are more comfortable with it. Like, for example, online and webinars, everybody's comfortable with it now. You know, whether it's arbitration, whether you're having an arbitration hearing or mediation hearing. So everybody across the world is becoming comfortable. So I think the speed at which, rather than whether or not they're going to be accepting it or not is one question, but I think the speed at which they will start to accept technology and probably artificial intelligence, I think it's going to go a lot faster than before.
Personally, I think we'll need to see AI being used in less sensitive contexts first and become comfortable with that before we start being comfortable with AI in a judicial context. I mean, again, coming back to the facial recognition example, the reason why there's been such a retraction recently to facial recognition is because we've seen potentially discriminatory effects of it. And so we're all thinking, hold on a second, this is too much too soon. Let's row back from that. But I think as soon as we start to see AI being used in day-to-day life a bit more, I think that will then make us a bit more comfortable in time with using it in a judicial context.
And to chime in there, I would also say that, I mean, asking the question like that, it becomes kind of pointed, because what we're talking about is how comfortable are people accepting science fiction as reality? Because we are talking about science fiction. If we were to have an AI judge actually ruling on big criminal cases today, this is going to build up slowly from behind, and maybe the last to go is going to be the veneer of humanity. But already today, a lot of people won't necessarily know the exact backbone or the back end of the judicial system. So that pieces of that is being updated with some AI might not necessarily be as scary once that is finally throughout, and once that is finally visible. People like us discussing this on panels, when we are discussing the science fiction concepts of it, that is scary. But if you were to say in early 2000s that one of the main tools I'm going to use when I assess arbitrators is I'm going to Google them, that would have also been extremely scary. And I would challenge that most of you probably do a Google search when you look at an arbitrator as at least one part of your toolbox. So I think this is you're gonna naturally be more comfortable with it. That's the same as the classic examples of imagine life pre-smartphones. We adapt exceedingly quickly, maybe too quickly, I would argue, instead, to accepting reality as a part of life. Oh, sorry, reality. I mean technology.
Yeah, technology.
Freudian slip there.
Yeah. So another big question, and I'd like all of your views on this, is to how the funding frameworks either disrupt or distract or maybe undermine an AI process. Because I think, as Lee said at the outset, that if you can fund it and you can fund bigger and better, then you can do that in a non-AI system. So what's the impact of the funding question on AI? Let's start with Tom first. Tom?
Yeah, I think that's a very good question, and I think it opens up a lot of these other issues about disparity and equal access. I think in terms of the funding, it's going to come from large clients, large companies. It's going to come from law firms, and like I said earlier, I think third-party funders will be investing in this. I think probably arbitral institutions may as well, at least in due course, once this area becomes a little bit more developed. And I think in that respect, it'll be interesting to watch the arbitral institutions over time and how they adapt to this, how they invest in it. Because I can see, look, there are a lot of great arbitral institutions out there, but it's an increasingly competitive area. How does arbitral institution A set itself apart from arbitral institution B? And one answer may be pushing the envelope on the use of AI in arbitration. I think an interesting development you've seen over the past few years is expedited procedures written into the rules of institutions like SIAC, ICC, and many others now. I could envision a scenario where you have sort of an array of options when you go arbitrate at an institution. You may have the old-fashioned way, the normal proceedings. You may have an option to do expedited proceedings, and you may have an option for AI proceedings. That might be an area where some of the funding comes from. But I think at the end of the day, a lot of it is going to come from the tech companies. And I think that opens up another interesting issue in my mind. Do you put the cart before the horse or the horse before the cart? Do you come up with the technology and then find ways to apply it to the law? Or do you have problems that arise in the law and arbitration proceedings and then find technology to resolve those problems? I think the latter approach is probably the better approach, but I think in practice the earlier approach prevails sometimes.
Prof, you know, when you mentioned funding, right, I'm assuming you're saying funding for developing AI. Is that right?
Yeah, or actually funding of your AI system to resolve your dispute. So, for example, there are big names, we've talked of some, but for instance, Amazon has its own Amazon arbitration scheme. So they've thrown a lot of money at it. You know, and I think there are several questions on this, but one question directly says, does money make a difference in terms of what you get as an AI outcome, which is what you were discussing, Anil, before?
Oh, so it kind of scares me because two things come to my mind straight away: the Terminator series of movies, right? You know, and how you know what they developed, and eventually whether it's taking over the world and all of that. And two is not to be political, but I remember just 6 months or a year ago, I think US was tightening down or putting sanctions on China and one of their mobile network, and how it could reach out, whether or not there was you know, they're so ingrained in the systems and satellites and defense systems and all of that. So when you talk about funding, I think it can be a very tricky area because, you know, does it mean that the larger, more powerful organizations can start going down the path of artificial intelligence development, and that embedded in their system, which might come out in you know, once it's operational in 15, 20 years down the road, you start to see, you know, the encoded stuff that's really going to confuse everybody or mess up our whole ecosystem and humanity. Quite scary. I think it's quite scary to think about that.
So Thomas, what's your thoughts on scary funding?
Yeah, I wanted to pick up on a couple of things I've heard. One is about the institutions, and in reading up for my comments, I came across an interesting article from 2018 in the ICC Bulletin about robot arbitrators, and proposing that institutions might be the ones, whereas in my model, I talked about a MedArb system where a human works together with an AI system to issue an arbitral award. This article was arguing that institutions might be that human who effectively endorse the award and issue the award, and thereby get around the problem in many jurisdictions that it must be a natural person who issues an arbitral award. So that's one idea I'm putting out there that I've come across. On the point of funding, I think an interesting issue or point to take into consideration is who is already using similar technology to help them guide their decision making. And I think banks are doing so. Investors, hedge funds, etc. And I think banks are also getting interested, and similar institutions, in funding arbitral cases. So once those components are put together, I think it's inevitable that we will see financial institutions leveraging their AI, or at least tech influenced backgrounds in their decision making, to see how that might influence whether they invest in cases. And we also have to take into account the distinction between whether the AI is assisting the party, as Lise mentioned, versus my points, which were more focused on the AI assisting the arbitrator.
Okay. Minesh, we've had a comment in about that family law seems to work well with ADR AI, and that's an emotional sort of area. Any reply to that?
I'm a bit surprised at that, actually. For me, family law is an area where actually human empathy is actually quite important. So that would be an area where I would perhaps say that AI may not be suitable. And I raised this point. I was speaking on behalf of the UN at a conference to the Dubai judiciary a few months ago. And I asked them, you know, as judges, if you were faced with a case where someone had been accused of theft, but it turned out during the trial that they were homeless, and they, you know, the classic example, moral conundrum, a homeless person steals a loaf of bread to feed their family. Can you ever trust AI to be able to exhibit the necessary human empathy to decide that case with the level of morality and human sentiment that we would all probably need to maybe, I don't know, pass a slightly more lenient judgment on that person, given that they were homeless and just trying to feed their family? I'm not sure. And in a similar context, in family law disputes, I think that's absolutely where you need humans.
Yeah, can I just add on to that? I think that the question also asked about whether he says arbitration has become a welcome tool in matters of family divorce. Not really, you know, because only certain jurisdictions are using arbitration as a way of resolving matrimonial matters, like Australia does and all of that. But interestingly, taking on Manesh's point, I sat as a mediator in a family matter, and the crux of the matter was $50 million worth of assets in 15 properties, right? And we literally had to put up a massive screen and then put down 1975, this property was bought, and whose share was it? And then when it was sold off, what did the share go to, and had to draw it. So in that situation, not the divorce per se, and the emotions and the family care and all that, when you're talking about asset division, I think an AI platform would have done wonders in solving this 15 properties. And
well, I'm sure that's why it's so successful in construction, but let's not go there. Barish, you're going to make a point.
Yeah, I mean, I wholly agree with Minesh on use of artificial intelligence in family disputes, especially around the issues of empathy and some might say more broadly justice. I guess there's a couple of things. I mean, are we using the artificial intelligence for procedural matters or substantive matters? And there might be a case for saying that AI might be of use in sort of bringing efficiencies about in procedural elements, for example, in a way in which documents are sort of exchanged and the way in which a process moves from one stage to another. So I could see it having a role there. But in terms of the more substantive issues around decisions that have to be made, I absolutely agree with that. I'd just like to make a very quick point on the funding point around research and development. I mean, there's a lot of organizations pumping a lot of money into R&D in the artificial intelligence legal tech space. And in doing so, of course, they're drawing upon data which might be more widely available. And that begs the sort of ethical question as to whether they have an obligation then to maybe open up some of the code and some of their sources to enable other organizations which might not have that money to be able to develop their own technology. So what responsibilities do those companies that have a lot of money to invest have to kind of support those organizations that might not have the same financial resources to develop that tech and to ensure that we don't have a two speeds developing effectively?
Yeah, that's a good point. Lise?
Yeah, I was just gonna add to the comment on by Minesh, and I would completely agree that family law might not be an early adopter area for AI, or should not be maybe, and there's a lot of human aspects that really need to go into that field. But I also wanted to point to, there's a classic study from Israel, and I'm sure that you've heard of it from a few years back, where they did a study on the approval rates for, I think it was permit paroles for inmates, and they had 1,150 cases, I believe, so a fair amount of cases that they looked at, where the judges in 35% they approved this the request or the appeal request when it was pre-lunch or pre-breaks, and about 65% when it was post-lunch or post-break. So hungry and tired lawyers are not necessarily your great human, ethical and morally inclined person. Just as we all get a little bit bitchy when we're hungry, so does the human lawyers. So even when you do talk about these kind of important human values, we as humans are not always good at displaying them. So I would still say that even in these contexts, you would maybe want to have some sort of support to verify that I'm not just being hungry right now. Yeah.
Okay, well, let's press pause there. We have had one commenting just about, you know, criminal proceedings. You can always have a harsh judge and a lenient judge, and how AI would cope with that would be as interesting as it would be in the family field and the construction field. So, you know, it does cross all jurisdictions and all areas of law. It's incredibly pervasive. As with all wonderful panels and wonderful webinars, we've almost come to the close. We've got 10 minutes, and as I promised those in attendance that I would allow the panelists some time to summate. Colleagues, in your summation, if you may, there's some points come up. One is Minesh less pessimistic? Is Lee's less positive? So we may want to address that. But equally, of course, we've got lots of students who are interested in this sort of debate, and they're asking in volumes, you know, is AI the future, and should they prepare themselves for that more than anything else to become future lawyers? But I'd like you all to address your final comments on the impact of AI in arbitration. So I think this time it's only fair if we can go in reverse. So we'll start with Thomas.
Good. Well, I think from what we've heard in the last few minutes, there's a point that neatly dovetails with my main proposition, which is that humans and AI can work well together. On the point of facial recognition, absolutely, there's been a lot of controversy about that and the in-baked bias. But I think it's known that some police systems work by employing humans, and particularly some that are called super recognizers, to assist their video review and make sure that the individuals that have been identified by video are the right people, and that support is working hand in hand with human review. So I would say that kind of approach is the one that we can expect to see, I think, also in arbitration, that humans and AI will be working together rather than the more scary proposition of an AI run amok and issuing arbitral awards completely independently.
So, thank you, Thomas. Anil.
Yep, I agree with Thomas. You really need to appreciate that we're not going to be taken over. We have to appreciate that what's going to happen is that we're going to have to embrace it and work with it and realize, like, you know, I've been in practice for 25 years now. When we started off, we had to do so much of groundwork as a junior lawyer. All of that's going to be taken away so that you can be sitting down doing far more productive review of the matter and then getting ready for the case. So just have to appreciate that you don't have that menial labor intensive work, and you're just going to focus a lot more on intense personal humane approach to dealing with disputes and arbitration for that matter. So you don't have to fear that, especially the students in the group. You really have to embrace technology. That's it.
Thank you, Anil. Tom.
So AI is not the future of international arbitration, but it's certainly part of the future, just like other forms of technology and other issues are going to be. And so I think, especially for young lawyers, you need to encounter it, you need to study it, you need to understand it, you need to see how it can be usefully deployed, not just AI, but other forms of technology. You know, the introduction, I started off with a reference to the current COVID-19 pandemic. And, you know, I think there's a case to be made that a lot of the tools and online platforms that we're using in the international arbitration community have been there for a long time. And we're not really being innovative. We're just being forced to use what we've already had. And I hope this will be a sort of a catalyst for us to continue in that vein, to understand what the tools are that are available and how they can be implemented. And I agree with Thomas. I think at the end of the day, it's going to be humans and AI working together. And I think at the end of the day, at least for a long, long time, it's going to be the humans in the driver's seat using AI as a tool or an assistant.
Thanks, Tom. Parrish.
So one of the questions I often have within the technology circles I run is are we about to enter an AI winter? And I don't think we'll be entering a winter, but I think we'll be entering an autumn, where the hype around AI will, I think, die down, but it will become a greater part of our lives going forward. And I think it's inevitable that we will see the greater use in artificial intelligence and those forms of technology. And I think it's important and incumbent upon universities and law schools to give their students training in that. So I do believe it's here to stay, and it's fundamental that young students and those entering the profession are given those opportunities.
Thank you, Paresh. Minesh?
I completely agree with Paresh. AI is the future. It's going to be a big part of our future generally. It's almost limitless in its capabilities. I think it will be used in the judiciary in due course, and certainly in arbitration. There are concerns, the confidentiality of arbitration, the fact that institutions are competing against each other. There's a risk that AI can be used improperly or lead to issues in arbitration. So it shouldn't be left untapped or unregulated, both in arbitration and in the world generally. But I will take up your invitation to finish on a positive note, and it's something that Lisa's mentioned. We do seem to expect perfection from technology, and artificial intelligence included. But I think, as recent global events have demonstrated, humans are far from perfect. So let's not criticize AI too heavily if it's not 100% perfect. For me, it's about striking the right balance.
Thanks, Minesh. And I bet lots of listeners, participants will be pleased to see there's a growing positive, but we recognize and understand the underpinning underlying pessimism. Last but by no means least, hopefully on a positive note still, Lise.
Well, I was gonna take up your invitation to end on a negative one, actually, by saying that I was always negative. It's just that I'm more negative to our current state of affairs. That we have, with 15 lawyers giving 15 different answers, lack of access to justice, backlogs, inefficiency, bias, and corruption, and all that we're struggling with today. I would argue that we have a moral obligation to examine these tools to ensure that we get to a better place than we have today. And I think that they carry a great promise in that. But that means that, for me, I would say, yes, this is coming. So yes, you should buckle up and prepare for it. It's not going to be an overnight shift. It's going to creep in here and there. It will change the balance of the playing field today. And that means that even though the basic principles of fairness, access to justice, and equality under the law will remain the same, the threats to it will be different. And that means that we do need to have a carefully examine the safeguards and the procedural tools that we have today to protect those core values, because the threat is going to come from a different angle than it usually does. So that was my five cents.
Thank you, Lisa, and thank you all. Well, I said at the outset, we would have a fascinating, informative, and engaging 2 hours together, and we certainly have. I think, in conclusion, the legal tech revolution continues, but I do think, as we've identified, there's still the big data debate to continue. In terms of AI and arbitration especially, the 3 R's are central: risks, regulation, and reasoning. But of course, we've had wonderful examples of how it does work, and how the ethical issues are very prevalent and do need to be tackled, but they are for the moment managed. So some wonderful discussion, some excellent questions. And as I always remind students at the outset of anything that we are examining or scrutinizing, today's keywords were artificial and intelligence and arbitration. And all of those 3 elements have their own distinctiveness, but they also have lots of advantages, but equally they have lots of challenges. And when they collide together, it results in a wonderful debate such as this, which I'm sure will continue and will resolve some of the challenges. Can I first of all thank the panel, not only for their time, but their valuable insights, experience, and expertise, which is greatly appreciated. Can I also thank all of the participants for joining us and for their excellent questions. I now have a complete stack of questions for students, so I'm entirely indebted to you for the next 2 years at least. But last but by no means least, for the final time, I'd like to thank Forte for hosting these marvelous webinars, not only today's, but for over the last 3 days. but I'd like to personally thank them for today's and the privilege and pleasure of moderating this debate. I hope you all have an enjoyable afternoon. Thank you very much for joining us.
Well, thank you very much, everyone. Thank you to our panelists and our fantastic moderator, Professor Stephen, for a truly engaging discussion. I mean, I'm no expert in this field, but I feel like now I might be now. So thank you very much to our panelists and our moderator once again, and we look forward to seeing you later on. We have one last webinar for today, which is later, which is IP Law and Tech. So if you do wish to register for that still, you can via our website. So thank you very much, everybody. Bye.